Seeing none, are there any other members wishing to speak? The Honourable Member for Calgary Elbow.
Thank you very much, Madam Speaker, and pleased to rise to speak to Bill 22. It is, I was going to say it's the culmination of a long process. It isn't actually, I think, the end of this process. I sincerely hope it isn't. And having talked with the Minister and some of my colleagues in the House, I truly believe that it is not an end, although I think we have to acknowledge that it is a very important step forward and has come out of a lot of the very good work done by the all-party child intervention panel. You know, the process, I think it's important to remember how it is that we got here. And this is not something that's just come up. This has been an ongoing challenge for the government of Alberta. Certainly events prior to this government coming into power. I think it's important to never forget the late and very much missed Manmeet Singh Bhullar and the work that he did on this file, and ministers before and since, every one of which I think in their heart had child's interests at the forefront. But I think we also have to acknowledge that there have historically been some tremendous shortcomings in Alberta's child intervention system, and nowhere is that more true than in Indigenous children's experience, Indigenous families' experience with the child intervention system. It has for many, many, many years been an extension of a colonial attitude which is manifest in residential schools, is manifest historically in the 60s scoop, and in many ways, and we heard this from many Indigenous people through the process, it feels like the child intervention system is really no different than those things. It is about separating Indigenous kids from their families, and that must end. And I believe that Bill 22 is an important step in the right direction. Not an end in itself. I don't think we're there yet, but I think it is an important step in the right direction. So the process itself was a very, very good process, and I want to thank the Minister and the government for agreeing to make this a truly open, all-party, non-partisan process. It is an emotional issue. It will continue to be an emotional issue. I would hope that in the debate on this bill that we continue to do a good job of not making it a hard partisan issue, that we really focus on outcomes for children, which is why I think all of us are here. I want to take this time on the record and formally to not just thank the Minister, but to thank the members who are on the panel, Madam Speaker, yourself included, members here in the House today who were part of that process, members from the United Conservative Opposition provided a lot of thoughtful input. The Honourable Member for Calgary Mountain View, the Liberal Caucus, members on the government side provided tremendous insight, lived experience working with child intervention. The experts that we had on the panel, Bruce McLaurin from the University of Calgary, Tyler White from Siksika Health Services, Dr. Peter Choate from Mount Royal University, and the newly made Senator, Dr. Patty Laboucan-Benson. We're very proud of her for ascending to the Red Chamber in Ottawa, and I know she will represent Alberta, Métis people, Indigenous people, and Ukrainians very well in the Assembly. And so I'm very proud of the opportunity to have gotten to know all of those people. Most importantly, though, are all of the people who participated in the process, who came out, shared their deeply personal stories. The opportunity we had in the all-party panel to travel the province, to travel and meet on reserve in Treaty 6, 7, and 8, to hold open houses around the province, to hear from Métis people, to hear from now adult children who have lived experience in the child intervention system. It was not a fast process. In fact, it needed to be a methodical and thoughtful process, and it was that. And so I give the Minister and the government a lot of credit for going back almost 2 years now when this panel was first struck. The first iteration of it, frankly, wasn't good enough. I was joined by members of the opposition side to call for changes to the terms of reference, and to the government's credit, they heeded those calls. And so this process has resulted in this bill, and I believe that it has taken us forward, and we are in a better place. I would hope that the government would learn from this process, that perhaps there's opportunities in other areas where we could follow a similar process, which I think would actually result in a little less noise in the chamber and a little more in the way of thoughtful governance for our province. So I would hope that that's something that we could see more in the future, regardless of who the next government would be. I can assure you, if we find ourselves in that position, that's something you could hold me to. But this process itself was a very good one, and again, I want to make sure that everyone knows that I believe it was a very positive process. So the details of the bill, and I think where things will be improved for the children who find themselves in contact with the child intervention system and for their families. The probably number one thing that I'm happy to see is an increased emphasis on safety. So previous, as the Minister has said, the previous Child, Youth and Family Enhancement Act focused on survival, just bare survival. And I think that none of us want to simply survive. I think we want to be safe, we want to thrive, we want opportunity. So changing from the word safety being in the old Act, I believe it was one time, and having not had a chance to count every single word, I think it's upwards of 15 to 20 times this word safety now appears in the amended Act. And that's a vast improvement. The member for Calgary Hayes had talked about the principles that we're talking about here. When we're making laws, you certainly do need to have black letter law. You do need to say the rules enable you to do this or prevent you from doing that, or say you must do these things in this order. That's important. It's very important in child intervention. But one of the things we heard from the frontline child workers, and let me just pause at that point to mention the people from within the system, both the people in the front lines of the child intervention system, the management and people who are policymakers and who work in oversight, people who work in agencies, foster parents themselves. These are all people who had come and spoken with the panel as well. And what we heard from the frontline workers in particular is there is a procedure manual that is upwards of 1,000 pages. And when there's an unfortunate incident, the 1,000-page procedure manual becomes an 1,100-page procedure manual, and then 1,200 pages, and who knows where it ends. And while it is important that we have actual procedures, and we can't simply have a free-for-all, well, I think what is more important is that we have a principle that drives the work that we do. We heard some really compelling stories where, in fact, a frontline child intervention worker was sitting before the panel, sitting next to his boss, and said, here's a situation where I went outside the rules because in the moment it was the right thing to do for that child, and we had a good outcome as a result. And turned to his boss and said, I hope I'm not in trouble. Technically, he was outside that 1,000-page binder, but what he was doing was the right thing for that child in the moment. And it was a good outcome for that child, and those are the kinds of things that I hope the 13 new matters to be considered when supporting child safety and well-being that are embedded in the Act. I hope that we can move to a place where the best interest of the child, given all of the complexities and all of the context of that particular child's situation, are weighed and considered. The other thing that we heard time and again from the panel is the importance of cultural connection. So the mandatory home study and cultural plan that's embedded in this Act is a welcome change. Had a nice opportunity to talk with Adam North-Pagan of the 60 Scoop Survivor Society yesterday, and he's very encouraged by that particular aspect of the bill, and as am I. I think it's very, very important that as this moves forward, that the Minister, the government, and all of us continue to engage in dialogue with Indigenous communities to ensure that in fact what we are intending in this bill is actually helping. and that walking together and co-creating that future, which are some of the terminology that is surrounded and framed the work that we've done and the reports and the outcomes. These are very important things. They shouldn't just be words on a piece of paper. They must be thoughtful actions that are put into practice every single day. I'm hopeful that will be the case. That then ties to First Nations automatically being notified of every application for private guardianship. There were cases that we heard repeatedly where Indigenous communities would not know, would not be notified when children who were part of their community were subject to a private guardianship or permanent guardianship order. And so that exacerbated or really frankly was an indication of the continued colonial mindset where kids are taken away from. So ensuring that Indigenous communities continue or will be engaged in that process is very important. And then also consolidating all of those private guardianship applications under the Child, Youth, Family Enhancement Act as opposed to splitting them between the Family Law Act and Child, Youth, Family Enhancement Act, I think will also help. As the Minister said the other day, the best court proceeding is no court proceeding at all. If we can avoid getting to court in the first place, that's always preferable. Sadly, sometimes the courts do need to be involved, but ensuring that notification is a very, very important part of that. Focusing on the child, one of the things that I've observed in not just the child intervention system, but this huge machine that is government, is that when an individual goes within and between different departments, or the status changes, you turn 18, you turn 65, you hit a certain income threshold, you fall off a cliff, and all of a sudden your supports are gone, or you need to know to apply somewhere else. So the fact that financial supports for permanency will not end when a child's guardianship changes, that the past was a challenge. So those supports and that funding following the child, frankly, it's amazing that wasn't the case in the past. It's unfortunate, but this bill would change that, and I think that's really, really important. Also moving from the 16 matters that should be considered in all decisions, offered too much latitude and flexibility. I talked earlier about the importance of principle. Sometimes it is also important to have some black letter law. So the 13 matters that are to be considered must be considered when supporting child safety and well-being. Are welcome, and the fact that those are also updated from the previous 16 is very important. One area that I noted when I first saw the 13 changes, which I thought was important, was the identification of Indigenous identity as one of the matters that must be considered. And as we know, 70% of kids in care are Indigenous. That is a vast overrepresentation relative to the population of our province, which I believe is less than 5% of kids across the province are Indigenous, but 70% of those kids in care are Indigenous. So that's very important. But equally, cultural connections. And cultural connections are important to Indigenous people, but they're also important in Alberta's multicultural society. And we talked about that with the Minister when we discussed this bill first, is those multicultural connections, regardless of what that culture is, should also be considered, and I'm pleased to see that that is embedded in the bill. So I'll conclude my remarks by saying that the bill is an important step forward, but we're not done. I'm glad to hear the Minister acknowledge that there's a phase 2 to this, which would come forward in future legislation, which would address the questions that we heard about the band designate and that role, and that the work is ongoing in consulting with Indigenous communities and band designates to make sure that that is properly resourced and properly considered. And while I will certainly vote in favor of this bill, and I am optimistic about the future, and I think this is a turning point, it's important that we keep going. And rest assured that the Alberta Party Caucus will continue to be steadfast in our pursuit of making sure that the promise of this bill is realized, that the changes that have been committed to going forward are in fact made, that the principles that are enshrined in this bill are followed. Thank you, Madam Speaker.
Thank you, honourable member. Are there any